want to hear from every single one of you in a private chat, how many square feet are in 1 acre? How many square feet are in 1 acre? I'd like to hear from everybody. How many square feet are in 1 acre? Did I get everybody? Everybody weigh in? Looks like we're good. General consensus is there are 43,560 square feet in 1 acre. So good job. Know that number. Continue to know that number. It will appear again.
Your tip really helped because I didn't have to look at my notes.
We like the 4 little old ladies, don't we?
Yeah.
4 little old ladies driving 35 and a 60. So I don't know if I have any NASCAR fans. Have any Petty fans? Isn't his number 43? So the other one I heard is Richard Petty would win 0 races if he was going 56 or something like that. I don't know if you're a NASCAR fan. There's other tips you can remember, but we all seem to like the 4 little old ladies going 35 and a 60. Any questions about anything before we jump in, pick back up in Unit 5 and get started?
Okay.
There you go, Tom. Yeah.
Sorry. On Unit 2 test online, it had mentioned all of this is about timeshare except, everything is true except. And one of the things that it said verbatim was right here. It says, for an example, it said that you must renew the registration by June 30th. So then the next thing is what they said that I was incorrect, but it's right here and it was right there on the answer. Developers must give prospective purchasers public offering statements prior to the contract. I mean, it says it right here.
So okay, so you said something about the first piece was about renewing. I need to see the question, I guess is what I'm trying to say. I need to see the question. So can you tell me what number that is? And then I'll look at it at break and we can address it when we come back.
I had the same issue, Carrie, with that question, but what it is the answer. I mean, one of the options, it says showing the offer right before showing the property. And is the answer, the correct answer is before the contract. So I know which one you're talking about because I just went to it. So whatever the timeshare, they have to offer something before the showing was one of the answer choices, but that's incorrect. It's before the contract. But I had that same question got me with that one word. I forgot what question it is, Julie.
Okay, thank you. I'll have to look at that again then. Thank you.
If that helped, if not, let me know and we'll be happy to address it. Thank you, Kelly. Someone just asked in the chat for our YouTube channel link again. So I just threw that back. If you guys check your chat, you can click on it, subscribe to it, bookmark it, copy and paste it. But make sure that you refer to that. Okay. 22 Unit 2. Great. I will look at that on break. Let's see where we are. 222. Okay. So let's get back into Unit 5, wrap up Unit 5. So last night we talked about, in Unit 5, we talked about different methods that we could use to transfer title. So we have some voluntary methods, some involuntary methods. You could transfer title by descent. You could transfer title by will. Remember when we started this unit, we're going to start talking a little bit more about title, and we're going to talk about the attorney's responsibility, the closing attorney's role and responsibility. And remember when we started this unit, we talked about title and deed. Title is the idea of ownership. Deed is the proof. Deed is the tangible piece of paper that you can touch and say, look, I own this property. So they're both evidence of ownership, or, you know, proof of ownership. Title's the idea of what comes behind the right to ownership. Deed is the documentary evidence. So now we're going to move and we're going to talk a little bit more about title and the attorney's role and their responsibilities when the buyer is buying. So first off, let me say this. In a real estate transaction, the buyer hires the attorney. The buyer hires the closing attorney, which means the closing attorney represents the buyer. And the closing attorney's responsibility is to make sure their buyer client gets clear marketable title. So one thing that the attorney is going to do to make sure that their buyer client gets this clear marketable title is they're going to do a very thorough search of the public records and find anything and everything on the public records that affect this property. Guys, these are public records. Who has access to and can view the public records? Everyone. The public, right? Where are my homeowners on the call? Did you know your deed was public record? Did you know anybody in the entire world could go out and find your deed? Did you know that? If you want to find your deed after class, please don't do it now. But after class, you can do a Google search for whatever your county is, do your county GIS. And the GIS will give you a lot of information that you need to know about your property, such as your deed, the tax bill. Again, please don't do it now, you guys. You won't be tested on your deed, I promise. So you can go to your county's GIS. The attorney is going to the same public places that you and I can. It's public records. They have public access. But the attorney is going to do a deeper dive. The attorney is going to go in, probably search more than what we are aware of. And what the attorney is looking for is we want to be able to hand that buyer a clear marketable title. And the attorney in their title examination is doing a chain of title. They're making sure that the conveyance is linked. And I always think about like a bicycle chain. So what the attorney's doing when they do the history search on the property, and give me a second to make sure I say this right. The attorney is making sure that the grantor on this deed matches the grantee on the previous deed. The grantor on the previous deed matches the grantee on the deed before that. They're making sure that the grantees and the grantor and the grantee lines up to make sure that those conveyances link. If they find a kink in the chain, that's called a cloud on title. Any kind of defect, any kind of conveyances that don't link, any kind of gap. If they find a cloud on title, then the attorney will get with the seller to clear up before they can convey, so they can convey to the buyer. Remember, the attorney's best interest is the buyer. So if there's any issues with the title, if there's any issues with the property found via the public records, then the attorney is going to get with the seller to clear it up. Maybe they owe money. Maybe they have some outstanding liens. I will talk about that more in just a second. Maybe it's something that needs to be handled legally. Maybe the attorney and the seller go stand in front of a judge and do that action to quiet the title, and the judge can fix or cure any cloud on the title. So the whole point, the whole purpose of this is to make sure that the attorney's buyer client receives that clear marketable title. Ideally, the attorney wants to be able to provide title assurance. This is the seller's biggest responsibility, is to deliver that marketable title. And here's the deal. Even though every single one of us have access to the public records, the attorney is the one that determines if it's marketable or not. The attorney is the one that gets to offer their opinion and say, this title is good, or this title needs to be cured. We have some things that need to be cleared up before we can convey that title. So the attorney, again, is doing this very thorough title search. They're looking at all the public records, any documents that might affect this title, might affect the conveyance of this property. They might be able, depending on the title, depending on the situation, they might be able to do an abstract of title, kind of like the Cliff's Notes, a condensed version. If they can go back and don't see any problems, then they might be able to offer this. Again, it's up to the attorney how they handle this. If they do find problems, then it might prompt them to dig a little deeper. It might prompt them to really spend more time investigating it to make sure the seller's handing the buyer that marketable title. In North Carolina, we have something called the Marketable Title Act. And what the Marketable Title Act says, that if the attorney can trace the chain back and have no kinks in the chain for 30 years, they can deem the title marketable. If we find a kink in the chain, they may go back more than 30 years to find the source of it, find the kink. Remember, we talked last night about, I think we talked about a situation where there was an estate and 20 people inherited the property and all 20 of those people were married. So we needed 40 people to show up and sign that deed. If 39 only showed up, if 39 showed up and one didn't, then we got a kink in the title. We got something that the attorney needs to clear up. This is the biggest reason why the buyer hires the attorney, is to make sure that they're receiving that clear marketable title. So what if the attorney misses something? What if there's a problem or an issue with the title that couldn't have been discovered via a public record search? For example, a forged document, a faulty document. If something's missed in the title search, or if the attorney wasn't able to find something, this is why the buyer gets title insurance. What do we know about insurance? Think about your health insurance, auto insurance. It covers you if something goes bad, right? It covers you if something goes wrong. Title insurance is the same way. Title insurance is here to protect the new owner in the event something goes wrong with the title that they received. Title insurance is going to protect the new owner from errors of the past. So title insurance is going to cover the new owner from the day they purchased, from the day they received that title back. Yesterday, the day before. So title insurance is meant to protect the buyer if there's something that couldn't have been discovered via a survey or a public record search, for example. Things that come up, that 1 out of 40 that shows up later and says, yeah, I never signed that deed. Title insurance is there to cover the new owner. Title insurance, if you are using a lender to purchase, If you have to borrow money, finance money, and use in a lender, title insurance is required, period, end of story. If you are a cash buyer, title insurance is highly recommended. The lender will require title insurance to protect their interest as well. So if a lender's involved, on the day of closing, there's going to be 2 policies issued. One for the new owner. Yesterday they were the buyer. Today they are the owner. So there's going to be a policy for the owner. There's going to be a policy for the lender, if a lender's involved. The owner's policy covers them for as long as they own the property. The lender's policy covers them for as long as there's an outstanding debt. Once we pay the lender off, the lender's out. They no longer have an interest in the property. There's nothing there to protect, nothing there to cover. Title insurance, here's the good news about title insurance. Title insurance, the buyer only has to pay for it one time and they're covered for as long as they owe. It's not like they got to renew it every year. So one-time fee, the buyer pays one time at closing. They get to pay for both policies. They get to pay for both their new policy and the lender's policy. And again, they're covered for as long as they own the property. In the event something comes up that couldn't have been discovered. So remember we talked about the survey the other night. Let's say your buyer waives the survey. Nah, I don't need a survey. I'm going to save some money. We go to closing, the title changes hands. The new owner later discovers, maybe they discover an encroachment, for example. The new owner goes to title insurance and say, you got to help me with this. You got to correct this. You got to help me make this right. Title insurance could very easily say, no. Had you gotten a survey done before you bought, we would have resolved it, taken care of it, and this issue wouldn't have happened now. So when we're trying to encourage our buyers to get surveys, it's important that they understand what they're giving up. It's not just saving a couple $100s on a survey in some cases. They could be losing their rights to be protected by title insurance because they opted not to have that survey. So the attorney is doing their very thorough search of the public records to make sure that the title is marketable, to make sure that the seller can convey that clear marketable title. The attorney, once they have performed their title search, their public record search, the attorney offers their opinion on title. And based on their opinion on title is when the title insurance company will agree to cover. Title insurance is not going to cover the new owner until they've received the opinion of title from the attorney. Until the attorney has said, I've done the search, I haven't found anything, it all looks good, cover these people. That's when title insurance agrees to protect and cover the new owner and the lender if involved. Again, if they find something, they're going to get with the seller to clear it up. That's their responsibility. That's what they owe their buyer client, is to make sure that that's clear. So let's look at a few examples together. First one says, after a title policy is issued on July 12th, 2017, it is later discovered that a 2010 deed to the seller was forged, thus making it void. Forged documents can't be found in the public record search. They can't be discovered in the public record search. There's no way the attorney could have found this by doing their search of the public records. Because there's no way that they could have found this, title insurance will indemnify the buyer because this title defect existed prior to the effective date of the policy and could not be discovered from the public record search. Again, title insurance is protecting the new owner from errors of the past. Things that the previous owner did to encumber the property. And there's no way something like this could have been discovered. Another one, buyer's buying. They declined to have the survey done before closing. After closing, the buyer discovers that a neighbor's garage encroaches the buyer's property by 2 feet. Owner's title insurance does not compensate the buyer. Title insurance is going to say, had you had the survey done, this encroachment would have been discovered and we could have taken care of. You waived it. These are the consequences of you waiving it. Title insurance, again, they're only going to agree to cover the new owner and the lender if involved once they've received that opinion of title from the attorney. The attorney is the only one that can offer that opinion. Let's talk about this idea of recordation, title recordation. Anytime we record, we talk about recordation. We're just referring to the act of placing the documents in the public record. We're putting the public on notice that these documents exist by putting them in the public records. They're going to be in the public records of the county where the property is located. The whole reason we record is to give the owner legal priority. They are the owner of record. Their documentation is down at the public records, down at the courthouse for everybody to see. We've put them on notice. Another big responsibility of the attorney is making sure when they're doing their recordation, everything has to happen in a certain order. So for example, before the attorney can record the buyer's new deed, they first have to record the seller's lien satisfactions. We got to show that the seller paid off their liens, paid off their existing mortgages, whatever other liens they might have had on the property, then record the buyer's new deed. And then probably not too far behind that, we're going to record the lender's mortgage or the lender's deed of trust. Remember, we talked about lien priority. Superior liens are paid first. All other liens are paid in the order in which they're recorded, except for the mechanic's lien is paid in the order in which the work began. With that lien priority, we're saying what order everybody's standing with their hand out waiting to get paid. And the lender wants to be very early in the line. They want to be way up there. So if we have to foreclose, they can protect their interest. So everything has to happen in a certain date and time stamp. It used to be, before the days of the internet, attorneys or their couriers would actually have to drive to the courthouse every day, stand in line, wait on that thing to get recorded. Does that not sound like a terrible job? Just go stand, hang out at the courthouse all day, wait to record deeds. Thank you, internet. These days, most counties, we do e-recording, which means you got to hit the button, you get confirmation from the Register of Deeds. Back in the day, before we were e-recording, there were a lot of things that could happen between the attorney's office and the courthouse, right? What if our little courier got in a car accident? What if the little courier drove off into the sunset with all those deeds in their car and said they can take this job and shove it? A lot could happen from point A to point B. I think we're getting more direct now, even today. I mean, can't we lose power? Can't we lose internet? So, even today, there's things that could still slow it down. But it just seems to be that it's a much more effective process. Is definitely faster. I know that much. So the attorney hits the button. do the e-recording, they get the confirmation back. And again, everything has to be date and time stamped in a certain order. So it tells a story. That's what we're looking for here. If anybody were to go back and research that title, they could say, oh, this person paid off all their liens and then they conveyed it to somebody else, and on we go. So last night, we briefly introduced you guys to the Conor Act. So let's officially meet the Conor Act on page 101. The Conor Act is the state law. The North Carolina Conor Act is the state law that says there are several documents that need to be recorded. And we'll talk about what those documents are next. There are several documents that need to be recorded so that they're valid against third parties. Why do we record? To protect the owner from third parties. We don't want a third party showing up trying to lay claim to any of the properties or the documents. So the Conor Act is the act that steps in, says there's certain documents that must be recorded in order to be valid. And then they specifically give us a list. These are the documents. The deed has to be recorded to be valid against third parties. The lender's deed of trust, also known as the mortgage, has to be valid, or has to be recorded to be valid against third parties. Leases for more than 3 years need to be recorded, Conor says. Easements, covenants. We're going to talk about installment land contracts and options when we get to Unit 10. Those are going to be recorded to protect the parties' interests. And then an assignment. If you assign your duties and responsibilities to another party, Conor says those assignments of properties need to be recorded as well. Again, the whole reason we record is to protect the owner's interest from third parties. North Carolina is known as a pure race state, which means the first one to get to the courthouse and records wins. It's a race to the courthouse to record the document. And the first one to get there wins the race. First come, first served. Guys, remember we said last night, failure to record the deed doesn't affect the validity of the deed. The judge doesn't care if it's recorded or not. The reason we record deeds is because, first off, the Conor Act tells us to. But the Conor Act says to record deeds to protect the interests of the owner. There's a fascinating story in your book on page 101. The second example there down near the bottom. Zackerman sells her property to Sands. Sands fails to record the deed. 2 weeks later, Shady Zackerman sells the same property to Hanson. Hanson suspects that Zackerman no longer owns the property, but accepts the deed and runs to the courthouse and records it. Because Hanson got there first, he now has the marketable title to the property, and Sands is out of luck. Sands may be able to sue, but who is the owner of record? The owner of record down at the courthouse is Hanson. It's a pure race. The first one to get there and records wins. This is why we have attorneys involved. Questions on recording? So North Carolina records, just briefly, other states may use something called a TORNS system. We don't do this in North Carolina, but it's just a land registration system. You just register your land. That proves your ownership. So if states don't record, they use the TORNS system. A good question comes in. Only the attorney has the right to record, or a citizen can do it. That's a great question that honestly, I don't have the answer to. I know attorneys do it, but I do not know if an individual can. I'm sure they can. It's public records. I honestly do not know the answer to that. Good question. Let the attorney do it. They know what they're doing. The last little piece in this unit is talking about something called North Carolina excise tax. Sellers have to pay this excise tax on the sale of their property. They'll tax you when you buy it. They'll tax you during the time you own it. And guess what? They're going to get you one more time when you go to sell it. And that get you one more time is called excise tax. You may hear excise tax referred to as transfer tax. You may hear some of us old school people refer to it as revenue stamps. It's all the same thing. Excise tax is always paid by the seller at closing. Excise tax is one of the seller's closing expenses, closing fees. We're going to talk about buyers and sellers closing fees when we get to Unit 21. We're going to talk about dues and debits and credits and all that good stuff that everybody has to pay. So how excise tax is calculated for closing? We always calculate it on the purchase price, whatever the buyer and seller agree to. Take that purchase price and divide it by 500. Here's the trick to excise tax. With excise tax, you're never going to have change. If you take the purchase price and divide it by 500 and you get change, then you're always going to round up to the nearest whole dollar. Always round up. This is the government we're talking about here. Round up. So there's no tax, or excuse me, no change with excise tax. And we always round up. So let's say, for example, the sales price is $249,750. Take that and divide it by 500, we get $499.50. Round up to the nearest whole dollar, which means at closing, the seller is going to have a charge for excise tax for $500. If we were to calculate excise tax and we divided by 500 and we got $499.01, we always round up. When it comes to excise tax, take everything you thought you knew about rounding and throw it out the window. Always round up. No change, always up. Again, we'll see this again. We'll talk about the sellers and buyers, debits and credits when we get to Unit 21.
Miss Julie, I got a question for you.
Yeah.
For that sales price, we shouldn't have rounded that up to 250,000.
You could do it that way also, Tiffany. You could round the purchase price and divide by 500. You're going to get, so that's, thank you. There's another good way to do that. I tend to prefer this way, but if you take 250 and divide it by 500, you'll also get that 500. So it's another one. There's more than one way to get to it. Other questions? Unit 5 is our attorney's unit, as in call your attorney. Big part of this unit is their responsibility. Their part of closing. So we got our key terms back on page 85. Key point review on page 103. The summary. And then the student quiz for unit 5 is on pages 106 and 107. There's the little math concepts on page 102. That's just talking about the excise tax. Questions on unit 5. Attorneys play a big role, big responsibility. We'll revisit the attorney as we get closer to closing.
So what is the responsibility of the title insurance again? Sorry, I got confused.
Title insurance protects the current owner from errors of the past. If something comes up on the title that couldn't have been discovered, that the attorney couldn't find, title insurance is there to help to protect the current owner. Not fair to make them responsible. You know, again, in practice, one of the documents that the seller signs is an affidavit saying this can't happen. It's an affidavit saying, I promise you, I'm giving you clear marketable title and there can't be any issues. You guys shake your head, yes or no. Do people lie? Unfortunately, yes. So could the seller sign an affidavit saying, oh yeah, everything's fine. I promise you're not gonna have any problems. They lie, they sign after closing, a problem comes up that couldn't have been discovered. Title insurance almost always will go after the former owner, the seller first. And if they're MIA or dead, again, they're there to cover the buyer, the new owner from those errors.
Well, they may not be lying when they sign the affidavit if
That's a great point, Tom. They may not know, like that. Yeah, absolutely. They may, that was mean of me, wasn't it? It may not be that they're lying. It may be that they don't know. What if you had that unsuspecting mechanics lien that you didn't even know about, right? So that's a good point, Tom. Thank you.
Oh, one question on that. Your example was in the year 2010, prior to that guy, somebody forged the documents. So therefore, what is the new buyer? Is he got the title or not?
He does have, he received the title in like 2017. So he got the title, then they found out there was a problem. Then they found out it was forged. But title insurance is going to help the buyer because you can't find a forged document on public records. That's what they're there to protect the new owner from, is things that we didn't know.
But the new owner does or does not get to keep the property.
Oh, absolutely, because they're insured. Their title is protected through title insurance.
Okay.
So somebody years back got shafted because their property was sold out from under them with forgery.
Yeah, possibly. It's interesting, isn't it?
Keep track, which is benefit to have public records, so we can check our own title and
Yep.
keep an eye on it every once in a while.
Yep. But it could be that somebody 30, 40, 50 years ago signed the document. It was forged. Things were different back then, right? And then it wasn't discovered until, remember, we're going to go back at least 30 years if we don't, or the attorney's going to go back 30 years if they don't find issues. They're going to assume it's okay. That doesn't mean that something didn't happen 50 years ago that could affect the title.
And say, isn't there one of these acts says there's a 30-year limit?
The Marketable Title Act.
So,
Okay. I want you guys to do something for me. I'd like you to turn to your book on page 100. I hope as you guys are looking ahead and going through your book, you're paying really close attention. I like the examples in your book. I like the in practices. I like the pictures and the figures. I think it helps bring things home. On page 100, the first in practice is a portion straight from our standard offer to purchase and contract. Now we're going to look at our standard offer to purchase and contract when we get to unit 10. But I want you guys just to take a minute. You guys see that paragraph that starts in italics that says seller shall execute and deliver? You guys take just a few minutes and read that. It's straight from our contract. Brokers should be familiar with the terms of the contract. We should be able to explain various things to our buyers and sellers, have conversations with them about it. As you guys are reading that, did you notice, let's go through this together. There's a whole lot of words in here that maybe you didn't know. How long have we been together now? 1 week or two? How long have we been together? Has it just been 1 week? 2 weeks? Okay, however long we've been together, there's a lot of words in here that we know now that we didn't know 2 weeks ago, aren't there? Things such as general warranty deed, a recordable form, which shall convey fee simple, marketable, insurable title without exceptions and mechanics liens, free from any other liens, encumbrances, including those which will be revealed by an accurate survey of the property, except this year's ad valorem taxes, utility easements, covenants, restrictions, we'll talk about those, and other such liens, encumbrances, and defects. I think it's important that you guys realize what we've been doing the last couple of weeks is working on defining some of these words, these terms, these concepts, so we can build you up, so we can in a couple units have a conversation about our offer to purchase and contract. So we can talk about our duties to the buyers and sellers and the things that we need to make sure that we're helping them with. So I want you guys to go ahead and give yourselves a pat on the back, because 2 weeks ago, if you read that paragraph, it wouldn't have meant a lot to you, would have it? Now it means a lot more to you than what it did. We've come a long ways in a short time, guys. We'll look at our contract again when we get to unit 10. And again, as I said, it's important that we are familiar with the contract. I'm here to tell you guys, for the most part, buyers and sellers are not reading their sales contract. Every once in a while, you get what we refer to as readers. But for the most part, buyers and sellers are not sitting down reading the sales contract. They're relying on us to make sure that we understand it so we can help them get through the transaction. This is why they hire us. And where we're heading is our relationship with the buyers, our relationship with the sellers, and how we get them through this contract to closing process, how we can educate them through the process and help them buy or sell. Other questions on unit 5? title deed attorney. Okay. You guys there? I glitched for a second. Okay. All right, we move right on into Unit 6. Unit 6. I really like Unit 6, and this is why. Unit 6 is the first unit that starts bringing in the broker's roles, the broker's responsibility. Starts bringing us into the equation. I hear you guys. We've been sitting here for however long we've been together now, battling on about easements and deeds, and you guys are thinking, this is not why I signed up for real estate school. Again, we're building up, and now Unit 6, we start introducing the real estate agent into the transaction and our role. Before we leave here tonight, the last thing we're going to do is talk about what next week is going to look like, because next week we're really getting the real estate agent involved. So I want to make sure you guys look ahead, know what to look ahead at, so we can be prepared for next week. As we get into this unit and talking about various land use controls, I think it's important going into this unit that we understand that as real estate agents, we should be the expert of our market. I need to be familiar with the area that I want to work. Guys, houses come and go. Properties, listings come and go. It's the area that we're working. It's the market that we need to be knowledgeable of. When you guys get your license, your North Carolina real estate license says that you now can assist in any real estate transaction as long as the property is located within the state of North Carolina. Once you're licensed, you can serve the entire state if you want to. There's no limitations on how much or how little you do within the state. However, with just saying what I said about us needing to be the experts of our market, with us being to be knowledgeable of the area that we choose to work, we may not want to take on the entire state. Some of you may want to just, for example, focus on Winston-Salem. Some of you may want to work Forsyth County. Some of you may be willing to assist in a transaction anywhere in the triad. You can assist in a transaction 3 hours away from you. But my question to you is, are you willing to do that work? Are you willing to drive 3 hours one way to assist that buyer or seller in this transaction? You guys with me? Just because you can work the entire state of North Carolina, you may want to consider having a market that you can focus on and be knowledgeable. If you choose not to work that transaction 3 hours away from here, then you could get a referral fee, agent to agent referral. How much? Please don't ask me. It's completely negotiable. We're going to talk about how you guys can get paid and when, your commission and everything you need to know about it is in Unit 8. We'll get you paid. But it's just things for you guys to start thinking about as we get into the broker piece of this. And if you know the market you want to work, you know the area you want to work, you may want to consider starting to learn about it. Don't let it take away from your study time, but you may want to consider learning more about it. I'll tell you, a great place to start is Google. Most of our cities have a city website. So if you Google like City of Winston-Salem, it'll pull up the town's website. If there's anything going on in the town, things you may need to know. Does anybody like to go open housing on the weekends? Few of you. You guys may want to consider popping into open houses. If you see a house in your neighborhood is open this weekend, go in and see what the inside looks like. Kind of see what it's about. I ask, if you do go open housing, that you do not walk in that front door acting like a super interested buyer. Please do not do that to the listing agent. We are used to people out there just being nosy, people just being curious. So will you guys promise me that? Don't lead the agent on, okay? But if you see something open this weekend, if you go to whatever your favorite site is to search for properties, Zillow or realtor.com, you can do a search for open houses and see what's nearby. And you can pop in and start seeing what homes in your market, your area are looking like. I think another good recommendation, as you guys are out and about running errands, turn the highway off your GPS. Force yourself to learn the different streets, the different neighborhoods, the different subdivisions in your market so you can be familiar with those areas. Again, all things for you guys just to start thinking about. I work with a lady, I remember when she got her license, she made it a point. When she left her house each day, she would not allow herself to go home the same way. She always made herself go home a different way. And that really helped. She said, that's how I got to learn my area, my market. I said, that's a great strategy. As you guys are driving around, if you see a yard sale and a sign, a for sale sign, make a mental note of the address, safely pull over and look it up on your phone. Do not look it up on your phone while you're trying to drive, but look it up on your phone. Get an idea what homes are going for in your market so you can start familiarizing yourself with it. Comments on that? By the way, we're doing open houses again because we got inventory now. I got something to show. The last couple of years, we haven't been doing many open houses because if you've been familiar with the market in the last few years, homes hadn't been available for 2 or 3 hours, not alone long enough to have an open house. So we're seeing open houses again. So if you gave up on them and you start searching for them, you can go back and find it again. Somebody says, what if we want to work a separate market from where you live? Is that something to be good to do? As long as you're willing to do the work. Again, you can work anywhere as long as the property is located in the state of North Carolina. It's up to you how far out you're willing to go. Does this make sense? I could help my friend buy a house in Wilmington because my license says I can. I don't know much about Wilmington. I don't know much about the city or the schools or the roads or anything like that. I would best serve my friend by referring them to an agent in Wilmington. That's the best thing I feel that I could do for them. Could I drive to Wilmington a couple times a week to help them in this transaction? Sure. The question I have is, are you willing to do that work? And that's what you need to, and that's why I need you guys to start thinking about how far out are you willing to go? Good question, thank you. Just because you can work the entire state of North Carolina doesn't mean that you necessarily may want to. Consider it. Other questions or comments? So before we really launch into Unit 6, let's go ahead and take our break. Let's take 10. I'm going to look at that question in Unit 2 we were talking about before break. We'll address that when we get back, and then we'll jump into 6. So let's take 10.